Okay, so now we're ready to go here. Pick up where we left off last night. Remember we started talking about how leases were structured and the four main structures of leases as far as how they end. Remind me what those were. What were the four structures as far as how a lease could possibly end? An estate for years, that's one. And so what is an estate for years? How does it end?
Definite date.
It does end. It ends definitely. It ends automatically and definitely when it gets to its expiration. So any definite, exact period of time is an estate for years. You are going to see that as a test question. There is 100% no doubt about it. You're going to have to be able to identify that. What's the other main type of lease structure? A periodic tenancy. And what makes that one unique? It automatically renews itself unless somebody gives what? Notice that they want it to end. Okay, good. What are the two much lesser types? Estate at will or tenancy at will. What does that mean?
End it at will whenever you want
It can end whenever either party wants it to. Yeah, JJ.
When I was going back through my notes, is that no notice required, like I want you out now, or is that just...
That is no anything. You're thinking too hard if you're trying to focus on it. A tenancy at will is neither party is committed to anything, so you don't need to ask any questions about do I need to just stop right there. What can you do in a tenancy at will?
So you just say get out.
Whatever the hell you want to do, because it's literally permission to be there. Neither the landlord has said, the landlord hasn't committed that they can stay for any period of time, and the tenant hasn't committed that they will stay for any period of time. So it's literally at will. It's only until they change their mind.
Okay.
Okay, does that make sense for everybody?
Was that home and family members?
Pretty much. I mean, but remember I said you have to be very careful not to accept what? Rent. Because if they're paying you rent and you don't have some kind of written drop dead agreement otherwise, what are you going to end up with?
Period.
You're going to end up with a periodic tenancy month to month. Yes, ma'am.
So then if you had started the eviction process and then you accepted the late rent, then it goes to the periodic tenancy, you have to start that eviction process all over
Again. You have to restart because you've started a new lease, right? Okay? So at will just literally means do what you want to do. Okay? And then what's the next step down the road? What's the last one? Tenancy at what? At sufferance. And who are those people?
They don't want to get out.
One step above trespassing. They've overstayed their welcome, Patrice said. Exactly. They're holdover tenants. They were there legally at one point, but at some point their lease expired. If it was an estate for years, it just got to the expiration date. If it was a periodic tenancy, somebody gave notice. But the key here is the tenant was supposed to be out, but they are still what? There. That's an estate at sufferance. And then we talked about the different ways rent could be paid. We talked about a gross rent payment. What was a gross lease payment? So fixed amount paid by who? The tenant. And who has to take care of all the expenses? The landlord. What about a net lease payment? The tenant takes care of not just the rent, but also taxes, insurance, maintenance, all those other expenses with the tenant's expenses. Good. We talked about a percentage lease or a retail lease. That's when somebody pays what? Their rent's based on what? Percentage of their sales. Good. We talked about full service leases, and those are usually used in what kind of space? Office space, specifically. Yeah. So it's going to include everything, utilities, janitorial. We talked about ground leases, right? Which is just the land, and they're usually for longer terms, longer periods of time. And then we got into the Residential Rental Agreements Act. And what do we say the Residential Rental Agreements Act says, first of all? That the property must be what? Safe for human occupancy. It's got to be habitable, right? It also says that who has to do maintenance in a residential lease in North Carolina? The landlord does. Is that negotiable? No, it is never negotiable. The tenant and landlord cannot engage in any conversation about not doing maintenance. That's not allowed in North Carolina. If the landlord's not doing what they're supposed to do, what right does the tenant have? Leave. Move out. What do we call that? Constructive eviction. It's constructive eviction. Okay, that's what that's called, constructive eviction, when the tenant moves out. Can the tenant withhold rent?
No.
Can the tenant pay to fix it and take it from the rent? No, absolutely not. Absolutely not. Good, good. Then we got into, we talked a little bit about the vacation. No, we didn't talk about the vacation and all that yet. We didn't, that's at the end here. So now that leads us up to the Tenant Security Deposit Act. Okay? The North Carolina Tenant Security Deposit Act. The Tenant Security Deposit Act is not a residential law. It's a law about any security deposit. Let's be clear about that. We've moved out of residential and now we're just across the board. All tenant security deposits fall under this law. Is everybody okay with that? Okay. Now, this is a state law. This is not a real estate commission rule. Here's why I have to point that out. Everybody has to follow it because it's state law. This is not a rule just for real estate brokers. This rule applies to everybody who owns property and leases it in the state of North Carolina. Look at what that first bullet point says about tenant security deposits in North Carolina. They must always be where? In a trust account. Notice I said, who does this law apply to?
Everybody.
Everybody. So anybody in the state of North Carolina who owns rental property and holds a tenant security deposit is required by law to keep that security deposit in a trust account. And I hear people sometimes say, well, I don't even know what a trust account is. Well, you better figure it out. Because if you hold a tenant security deposit, it's required by law to be in a trust account. Is everybody with me on that? There is no exception to this law. So let's get to the why that's important. Why do you hold a tenant security deposit in the first place? In the event, what happens? They damage the property, they don't pay you rent, they move out and break the lease, all those things, right? And all those things are reasons that you could keep a tenant security deposit, but only if you've been holding it in the appropriate manner all along. What I'm saying to you is this. I don't care if they walk out owing you a year's worth of rent. If you're holding that tenant security deposit anywhere other than a trust account, what is a court of law going to make you do with it? Refund it all back to them. You don't have an entitlement to it unless you've held it in the way this law says you have to hold it. Does that make sense for everybody? So the first step of holding a tenant security deposit is open a trust account. Get a trust account because that's where it's got to go. Okay? And so any failure to hold it there does sort of negate your claim. It means you don't have a claim to it. And a lot of people, how many times do you think this law is broken every day? Tons. 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 They put it in their personal checking account. Listen, there's a multitude of reasons why you wouldn't want to put a tenant security deposit in your personal checking account. Number one, if the tenant challenges you in court, what's the court going to make you do with it? Give it back. You want to hear the even uglier reason why you should never put it in your personal checking account?
They can't get it back.
Well, that's not, I mean, you die is pretty ugly. That is true. If you have a tenant who really wants to rake you over the coals, when they go to court and they make a claim that they want their tenant security deposit back, they're entitled to an accounting of the account where their tenant security deposit is held. If they walk into that courtroom and they say to the magistrate, well, Your Honor, I would like to see all the deposits and withdrawals made into the account where my tenant security deposit has been held for the last 2 years, and you are holding it in your personal checking account, guess what they're entitled to? All of your banking records for the last 2 years, because that's the account where you have held their tenant security deposit. Does it sound like a good idea now to keep it in your personal checking account? No. Create a trust account, folks. There's a reason for this. You need that wall of separation. Does that make sense for everybody? Okay. Get it in a trust account. Get it in a trust account. Now, the Tenant Security Deposit Act not only says it has to be in a trust account, it limits the maximum amount that you can charge. It limits the maximums that you can charge, and this will have potential to show up on an exam. Remember, when we talked about notice, the state set up minimum notice. That meant the lease could specify longer, but it couldn't go less, right? These are maximums. That means the lease could specify less, but it can't go what? More than. It can't go above these amounts. So if it's a week-to-week tenancy, the state of North Carolina says you can't charge more than a 2-week security deposit. If it's month-to-month, you can't charge more than a month and a half. And if it's anything longer than month-to-month, the maximum security deposit you can charge in North Carolina is the equivalent of 2 months' rent. That's it. Never more than that. And I'll tell you why this is there. When we haven't talked about fair housing yet, but it's coming pretty soon. When the Fair Housing Act was first passed in 1968, people, certain people, not all people obviously, but certain people looked for ways to continue to discriminate in housing without being considered guilty of discrimination. And tenant security deposits became the primary tool toward that end. Let me show you how that works. Marlo, we would love to have you as a tenant. So all you need to do is fill out this application, and we do charge a 2-year security deposit, just to let you know.
Yeah, I know you don't want me to remove.
Is that a pretty good way to discriminate? You know, because when she says, you're discriminating against me, I would say, why? I'm happy to have you. So, the Tenant Security Deposit Act in North Carolina, like in most states, came along to address that problem, and that's why you have these maximum amounts. Does that make sense for everybody? Okay.
Fair.
To be fair, right. So you don't use the tenant security deposit as a way to basically pick and choose tenants and especially isolate some out. And so that's why you have these maximum amounts there in the Tenant Security Deposit Act. Now, the Act also gets really detailed about what you can, and more importantly, what you cannot charge a tenant security deposit for in the state of North Carolina. So these are things that can be charged against a security deposit, but let me point out, not while the tenant is still there. Never while the tenant is still in the property. We'll say that one more time. Never can you touch the money while the tenant is still in the property. If they're in possession of the property, you don't have the right to touch the money. When can you get the money? When they have vacated the property, when they're out. So once they've vacated, then you can start to take that money for these reasons. Unpaid rent, that's the #1 reason you could take money from a security deposit. That's pretty obvious. Damage to the property. Now notice it says more than ordinary wear and tear. We're gonna delve deeper into that in just a second. What is damage and what is ordinary wear and tear? But in general, you can charge for damage. You cannot charge a tenant security deposit for ordinary wear and tear. Breaking the lease, so we also call that non-fulfillment of the lease. You can charge a security deposit. If somebody moves out 6 months before the end of the lease, do they owe that 6 months? Yes. Unless the lease specifies, could a lease specify, say, well, you know, if you break the lease, you just owe us 2 months? Could the lease specify that? Sure. Sure it could. But if it doesn't, you owe whatever the remainder is of that lease. Cost of cleanup and storage, if they leave you parting gifts, sometimes they do. All those wonderful things that they didn't want, they left them for you. You can charge the cost of cleanup and storage for against their security deposits. And if they did breach the lease, you can charge the cost of re-renting the property, like marketing it and that sort of thing could be charged against the security deposit. Now, you've got to account to the tenant. If you're going to take money from the security deposit, you have to let the tenant know what you took the money for. And you have to do that within 30 days. You have 30 days after the tenant vacates the property to send them an accounting, what you did with the money. If you're not taking any of the money, you have 30 days to do what with it? To give it back, to refund it. One way or the other, you have to send them some kind of communication within 30 days. If you don't send the communication within 30 days, you don't have a right to the money. That's another mistake that landlords make a lot of times. What if the tenant moves out and they owe you the last month's rent? Is that a valid reason for you to keep the security deposit? Sure it is, but only if you send them an accounting saying that's why you kept the security deposit. You can't just keep it and assume they understand why you kept their money. Because 2 months later, if they come back and they demand their money back, guess what you have to do? Give it back to them. Because you have to send them the breakdown within 30 days. Everybody okay on that?
Otherwise, it's refunded back.
Otherwise, it belongs to them. That's exactly right. You are required by law to give it. And I've had people say, well, I don't even know how to get in touch with them. Yes, you do. Mail it to their last known address. And then people say, well, that's my house. I'm like, and that's fine. Nobody said they had to actually get the accounting. They said you have to what? Send the accounting. You need proof that you've sent the accounting to them. So what I would recommend is send it to them certified mail. Send it to them certified mail at their last known address. If they don't go pick it up, that's their problem. Does that make sense for everybody? Okay. That way you've covered yourself that you're entitled to it. Yes.
The only way, if you're in the midst of a dispute situation like that, the only way to get over that is to hire an attorney, since the real estate commission is an enforcement, it's a state law.
What do you mean?
Well, like if you're a tenant,
okay,
and you think everything's fine, and you move out, you
Mhm.
don't get your deposit, you go, hey, what's up with this? And you never get an answer.
Yep.
The recourse is to get an attorney because the real estate commission can't help you.
the real estate commission cannot help you. That is correct. I would say getting an attorney is probably not the best step. I would simply file the suit myself in small claims court. It is an easy to file small claims action. Generally speaking, it is not worth what you would pay an attorney to to deal with it, even though you would get your attorney's fees back if you win. Most of the time, the clerk's office is very helpful in filing those things. If you go to the clerk of court's office and you say, listen, I moved out of this house and as far as I know, I left everything in good shape. I didn't owe them any money. They won't refund my security deposit. I haven't heard anything from them. It's been 2 months. What do I need to do? The people in the clerk's office are going to be very helpful about saying, here's the form you need to fill out. Here's the box you need to check. You're going to have to pay this much money to file it, but when you get your security deposit back, you'll also get awarded, the filing fee back. I would think just represent yourself with that. It's usually pretty easy. Pretty easy if you've not been through that process. I think people are very intimidated about that, but it's a pretty easy process. It really is. Okay? Now, this is a differentiation of what is wear and tear and what is damage. That's an important distinction in North Carolina. What things are wear and tear and what things are damage. Why is that an important distinction? Because you can charge a security deposit for damage and you cannot charge it for wear and tear. Does that make sense for everybody? Okay. Now, let me point this out. That does not mean you can't charge a tenant for other items other than damage. Like, for example, if your lease says you're responsible for shampooing the carpet, and you sign the lease, are you responsible for shampooing the carpet? Yes. And they can bill you for that if you don't do it. But they can't take it from what? Your security deposit. That's the difference. This law makes it very clear about what they can take from a security deposit. So, for example, if your lease says you're responsible for shampooing the carpets, and you don't, they have to refund your security deposit in full, and they can send a bill along with it that says you owe us $200 for shampooing the carpets. What they can't do is take the $200 for shampoo and the carpets out of the security deposit, because that's not a legal use of the security deposit. Is everybody okay on the differentiation there? All right. So damage, large holes in the walls, drawing on the walls, paint, unauthorized paint color, so they painted without your permission and painted some kind of wacky color. That's damage that you can charge for. Stains and burns on carpet, but I would say with carpet, it's going to be all about the age of the carpet. Most magistrates in this state assume that carpet has a 7-year lifespan. So if you are charging a tenant security deposit for carpet damage, you better be ready to document that the carpet is less than 7 years old. Because generally speaking, if you're charging them for damage and the carpet's 10 years old, the magistrate's going to look at you and say, you should have been replacing it anyway. Does that make sense for everybody? Okay, that's just an FYI. It's not on the test, but that's an FYI if you ever do end up in property management. 7 years is about what most magistrates will give for carpet. It's up to them, but 7 years. Okay, and if you think about it, that's kind of a fair approach. I mean, you know, if you're going in there and you're saying, well, you owe us $1,500 for damage you did to the carpet, and the carpet was 20 years old anyway, I mean, that's not really a very fair claim. And so that's kind of how they weigh that out. So, 7 years. Yes?
I didn't even know we had to get our carpets. Well, I didn't even know carpet had lifespan. And then I went, I'm like, you know, you got 5 and 10 year lifespan. I mean, you weigh it out automatically. So
right.
You figure you just take it up when it gets bad.
Right.
I didn't know it had like, this don't die.
Well, and I'll tell you where the 7-year lifespan comes from. That's the IRS's depreciation schedule for carpet. And so most magistrates use the IRS depreciation schedule as a kind of a guideline on how often the carpet should be replaced. And so what I'm saying is, this only comes up when there's a dispute. You know, like the landlord is charged for damage to the carpet. The tenant has gone and filed a lawsuit and says, no, this is not fair, I want my money back. So here's what the magistrate's going to ask the landlord. How old is the carpet? And if the landlord goes, no, well, and then the magistrate's going to say, well, how long have you owned the property? Well, I've owned it for 10 years. Have you ever replaced the carpet? No, it's the carpet that came in when I got it. That tenant's getting their money back, is what I'm telling you. Because the magistrate's pretty much going to take the position of, it doesn't matter if they damaged it, you should have been planning to replace it anyway, so the damage is immaterial because it was time to be replaced.
But some carpet actually only have 5-year lifespan too.
I'm sure.
Go to buy it.
I'm sure. Some of it's so thin it has a 2-minute lifespan, but you know, that's that we call it builder grade carpet, you know. It looks pretty. Don't walk on it though. As long as you don't walk on it, it'll be perfect. Okay? Is everybody good on what is damage and what is not? Generally speaking, cleanliness items are not going to be considered damage unless it is really excessively filthy.
But let me ask you this now. If you got these items like up top for the wear and tear, and okay, you agree that you're going to pay for the carpet to clean it, and you don't, I still got to give you your money back. And I hope you get my $200
That is correct.
Then if I don't get my $200, I got to take you small claims.
That is correct. That is correct.
Well, why would you make the landlord jump through those hoops when he already got them?
You have to talk to the General Assembly about that because they once passed the Tenant Security Deposit Act. So, I mean, it's, you know, realistically, that's the best answer I can give you, you know, because this makes it clear what you can and cannot do with the tenant security deposit.
Well, you know, I can see the advantage and disadvantage of that, because you got landlords that just want to take your money. They
Which
can
happens.
Start making up stuff.
Right.
But just take your money and then nothing is
I
left.
hate to say it, but apartment complexes are notorious for charging things that are not allowed by the statute.
I just moved out of my college apartment in June, and they sent me a bill for all, and they sent me my charges. And I knew it would be outrageous because we only paid $150. It was like college.
Right.
Well, I started looking at my statement, and I emailed them, and I was like, you know, according to, I pulled out my book, and I was like, according to the security deposit, they had charged me for carpets first, and I said, you know, it's not the lease, and I lived there for 3 years. I said, that's, you
That's wear and tear.
Wear and tear, and they gave me the money back.
And generally speaking, that's what happens. Generally speaking, when somebody pushes back, and especially if somebody bothers to send the tenant, because the Tenant Security Deposit Act, if you ever look at the actual statute, is very detailed about what is allowed and what is not allowed. And somebody bothers to just make a copy and send it to them and say, well, here's the North Carolina statute. You tell me how you can charge for this. Most of the time you get a check back that says, oh, our bad. You know, but they do it because, quite honestly, it's effective because most people don't push back. Most people don't know what is allowed and what is not. Correct. Correct. Absolutely. Okay. And then finally, last thing in the chapter is the Vacation Rental Act. This is an important law if you rent short-term rentals, because otherwise, if this law didn't exist, it would take you the summary ejectment process to get out a tenant who doesn't want to leave. Imagine if you were renting one of these properties down at Emerald Isle. And one of these houses could easily rent for $6,000, $7,000 a week at Emerald Isle. All right? Now, you've got somebody who leases that thing for a week and then they don't want to leave. Do you want to have to go through the summary ejectment process to get them out? No. How long does that take? 45 days. How much money are you going to lose in the 45 days it takes to get them out? So, the whole point of the Vacation Rental Act is what we call expedited eviction. It allows people who own and manage these kinds of properties to basically avoid the summary ejectment procedure. Does that make sense for everybody? It allows them to say, no, I don't have to go file for summary ejectment because we are a what? A vacation rental. So in order to qualify for that protection, you got to do a couple things. Number one, never lease the property for more than 90 days. If you lease the property for more than 90 days, you're going to lose all the protection of the Vacation Rental Act. That's number one. Number two, you have to make sure you verify that your tenants have a permanent residence somewhere else. The idea here is you want to do what with them? Kick them out. Legally, you can't kick them out unless they have somewhere to return home to.
Wow.
So, now, I've had people say, well, how in the heck do I verify they have a home? Well, you don't really. What you need to do is ask them for their what? Their home address. Your lease needs to specify somewhere, where is your permanent home address. As long as you've got that, and you can show you're not renting the property for more than 90 days, generally speaking, you're going to be considered a vacation rental, and therefore you can have expedited eviction. I've had people ask me, well, what is expedited? I say same day. That means you can kick them out same day.
I like that.
Same day.
You gonna really run this house?
Yes, and so, yeah, the police, the sheriff would kick them out same day. So if you're going to manage one of these properties, you need to be, prepared to show that it is a vacation rental. This is not a long-term rental. This is not a long-term tenant, which means you better have a written lease that specifies clearly that it's a vacation rental and it falls under the North Carolina Vacation Rental Act. Where would this also come into play? Because obviously we don't have many vacation rentals here in the Triangle, but what new services have come into play that might, Airbnb, VRBO, those kinds of leases might want the protection of the Vacation Rental Act. So if they want that protection, they better look into it and make sure their leases comply with the Vacation Rental Act. Yeah, but and I'm not saying you did see it, but I'm saying if they want that protection, they better make sure you are seeing it. Because otherwise they may end up with a long-term tenant. Everything's great as long as people leave when you expect them to. It's when they don't that you have a problem.
Didn't it happen in a story where a person was renting one and they ended up losing their home in the process and they ended up staying?
Oh, really? No, I had not heard that story. That's an interesting story. So they were renting a short-term rental and they lost their house in the process. Was it like a foreclosure or a storm or? And so they stayed at the vacation rental
And then the owner couldn't get them out
because of that.
because they didn't have.
Because they didn't have a permanent address to go back to. There you go. There you go. We have had people at the coast who have made the mortal mistake of leasing these properties over the winter for more than 90 days. And then spring rolls around and it's time for that person to lease. They call them snowbirds, right? You know, somebody comes down there and they lease them a lot cheaper during the winter, and somebody comes along and says, well, I'll take it from September through February. And they lease it to that person. Well, then March rolls around, okay, well, it's time for you to leave. No, I don't think I will. And now you got to go through what process to get them out? Summary ejectment, because you leased it to them for more than 90 days.
So now they get a 3 month and a half. That's so that's it.
Could be, could be. Are we good on that?
Don't they owe you rent?
They do owe you, absolutely, but, you know, getting it might be a whole different story. Yeah, it's the whole matter of collecting it, plus you've got other reservations that you now have to cancel because you have other people coming in, and it gets ugly. Okay, we all good on this? All right, that's it for chapter 11. Stop the video here. Y'all want to do a quick break before we do chapter 12? Okay, let's do that.